Here. So first off, just want to thank everybody for joining us today. We're excited to be here in the new year, and hope everybody's doing well. We've got some really great content, some very important content for you today regarding business associate agreements for 2021. So hope everybody has some valuable takeaways from today's presentation, and again, thank you for attending. And before we get things started, just a bit of quick housekeeping here. We are recording this session, so if you or anyone within your organization would like a copy, please be sure to let us know. And also, we have Tina with us monitoring the live Q&A. So as you can see, if you click on the question mark icon, it'll give you the ability to post a question. So we're going to leave some time at the end for today's at the end of today's presentation to answer those questions. So please be sure to be as interactive as possible. And for those of you who are unfamiliar with Vertical Solutions, we are a healthcare focused managed IT services provider. Excuse me. So you can see here some of the services we provide. Ultimately, we look to help practices best leverage their technology to support, ultimately your business strategy. So, and from our team here, we have myself, Justin Krentz. I'm an account manager here in PA. My counterpart in Denver, Tyler Lewin, Bruce Nelson, who is the president of Vertical Solutions, and also Tina Featheringham, who leads our marketing team. So with that, I will hand things over to Bruce to introduce today's speaker.
Can you hear me?
Yeah.
All right. So I want to thank everybody for taking time out of your day to participate in this webinar. We take pride in being able to bring thought leaders like some important and valuable information like today's session. We have a few highlights from Steve's career on the screen, but I want to personally thank him for hosting this session. Steve and I met in our Leadership Pittsburgh class way back in 2004. I think you're going to find two things today. Steve has a real passion for data privacy and compliance, but more importantly is a unique ability to take complex topics and simplify them for practical use. So I hope you enjoy the session. I hope you find value. I know I've found value in my relationship with Steve over the years and his insight and an ability to take those topics and really simplify them for even dummies like me. So with that, I'm going to turn it over to Steve, and thank you again for participating, Steve.
Well, thank you, Bruce, Tina, Justin, Tyler. It's most appreciated, and thank you for the kind introduction. I know time is of the essence here. So I won't waste any of it. And of course, if the session ends and you have additional questions or comments, please feel free to contact me or anybody at Vertical Solutions, because our job here isn't just to leave you hanging. It's to leave you with something that you can hang your hat on in 2021 and beyond. Okay, so I just want to give the atmosphere of this presentation for you, because I think that it's necessary for a slight change of culture to occur. And I base this upon my experiences as somebody who's practiced law for a long time. I'll let it go at that. And somebody who speaks nationally on contracts, has litigated contracts, and writes them. And as a matter of fact, as soon as I finish this presentation, I'll be working on another contract. But here's what I want you to know. And if you remember nothing else, remember this. Contracts are agreements between parties to the contract. They are not agreements between the lawyers to the parties of the contract. If you don't understand the contract, that is on you. I can't tell you how many times I've heard someone say, well, that's my lawyer put that in there. Well, sure, your lawyer may have put it in there, but if you don't understand what your lawyer put in there, then you paid for something that you really don't understand. And I don't think you want to go there. So that's item number one. These are not Contracts are not commodities. They are codes of conduct between parties under certain facts and circumstances. So don't look at them like they're all the same. They aren't. Now, that's item number one. Item number two comes up with these privacy quotes that you see on your screen. And I'm a big fan of trying to learn from people who are obviously smarter than I am. So on the left-hand side of your screen, you're going to see 5 quotes. And on the right-hand side of your screen, you're going to see 5 different people who have authored these quotes. I'm going to read them, and at the end, I'm going to tell you which quote goes with which person. And you can see I've included myself in this list. Quote number 1, they who can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. The second one, when it comes to privacy and accountability, people always demand the former for themselves and the latter for everyone else. 3, you already have zero privacy, get over it. 4, there are a terrible lot of lies going about the world. And the worst of it is that half of them are true. And then the last one, which I consider to be the most insightful, is if 2 people know something, it isn't a secret. Next slide, please. That last quote about 2 people knowing something and it not being a secret really takes us to where we are today, because we're talking about healthcare, we're talking about information that people give to their healthcare providers that they don't give to anybody else. So if you are a patient, you will tell your physician, oh yes, this is the last time I smoked cigarettes. It's been my experience that people will tell their physicians things that they won't tell their insurance carriers. So I want you to understand that we're talking not about secrecy, we're talking about privacy. People are sharing information that they want you to use for their benefit. Can we go to the next slide, please?
Hey, Steve, this is Tina. We have a bit of a lag. We're on the why, the HIPAA privacy rules slide.
Okay.
Okay.
Okay. So here's the scenario, the battlefield on which you find yourselves. HIPAA is but one privacy law that you're dealing with. It's a big one, and it's probably the most mature privacy law in the United States, but it's not the only one. There are some others out there. The Genetic Act, the FERPA, Federal Education Rights and Privacy Act, FACTA, the GDPR, the New York Department of Financial Services. You are doing business in this sea of disparate and disjointed privacy laws. What you should know about laws in the United States is that laws in the United States tend to follow the particular industry. So if you're in financial services, you'll have Graham-Leach-Bliley. If you're in healthcare, you'll have HIPAA and high tech. And there will be some issues as to what type of data you collect and what you do with the data as to whether the law applies. So why does the HIPAA privacy rule apply to you? The answer is simple. It applies to create standards that protect medical records and other personal health information. It applies to health plans, healthcare clearinghouses, and providers conducting certain healthcare transactions electronically. We store most of our data electronically today. And let me throw in a fact that I want you to remember for later on. From the beginning of recorded history through 2015, the human race created a certain amount of data. In the year 2016 alone, the data that was created in the year 2016 equaled the sum total of all the data that had been created in the preceding 2015 years. And in 10 years, the amount of data will double every 12 hours. The privacy rule requires appropriate safeguards, not complete and total, but appropriate safeguards to protect the privacy of personal health information, which we call PHI, and sets the limits and conditions under which those pieces of data can be used and disclosed without patient authorization. It also gives rights to patients, somebody like me, regarding our health information, including my right to examine, to obtain a copy of the health records, and, if necessary, to make corrections. Next slide, please. While we are waiting for the next slide, I want you to understand that privacy deals with the data itself. Security deals with what it is you have to do with electronically stored data. And since most of the data that we have and share and use is electronic, consider the privacy rule to be the master rule, and then a subset will be the security rule that applies to what it is you must do to protect the data. And one of the things that you have to do to protect the data, to keep it secure, is to put certain clauses in your business associate agreements. Okay, as we're waiting for the next slide.
Steve, we should be on the HIPAA security rule slide now.
It's not showing. Here, it is now. So the security rule that I just discussed. This applies to health plans, healthcare clearinghouses, and any healthcare provider and their business associates. The rest of the world calls those vendors, contractors, subcontractors. So if in your business you are doing work for a health plan or a clearinghouse or any provider, St. Elsewhere, for instance, and you are taking that personal health care information and transmitting it electronically, then the security rule applies not only to your business, but to everyone else's business. And that means that you have to have it in your contract with the healthcare provider, and you have to have it in your contract with your subcontractors. Because any information in electronic format has to have it. And this took effect in 2009. So, why is this happening? Here's the answer. HIPAA is a federal law. We all are very much aware in this day and age of the difficulty with which law enforcement is dealing with absolutely everything that is going on in our society. If you look at laws in the United States, and the security rule is one of them, what you are seeing is that the governments, the federal governments, the state governments, California, for instance, they are placing the requirement of data security on your backs. There is no gigantic data police force out there to make sure that these things happen and that they happen correctly. The reality is that this was, and always will be about money. And that's the biggest business purpose out there. I want you to adopt the frame of mind that data breaches will occur. What the business associate contract requires, among other things, is that there are financial mechanisms in place to pay for the work that has to be done in the event of a breach. The worst thing in the world isn't fumbling the football, to use a sports metaphor. The worst thing in the world is to fumble the football and not pick it up. You can go back to the other slide. So what the security rule says is all you people in the contractual line chain of privity, all you people have to make sure that if there is a data breach, then you are contractually protected. If you're the hospital, you're contractually protected with the billing service or whomever uses it. The next entity, the business associate, it will have a business associate that it subcontracts to. Very few companies are totally vertically integrated. And the requirement here is to make sure that contractual line, that contractual chain isn't broken on the financial side. Next slide, please. So I want you to envision a chain. And you have all heard the expression that a chain is only as strong as its weakest link. So imagine, if you will, you are somewhere in the middle of several subcontractors, covered entities, we'll call them. You are in the middle, and you have all these requirements from the business associate agreement and all the contracts above you, but for some unknown reason, you don't put it in with your subcontractor, then you're the last covered entity holding the bag. So who are you? Who are the covered entities? You are doctors, clinics, psychologists, dentists, chiropractors, nursing homes, pharmacies with some exceptions. You're a health plan that's a health insurance company, an HMO, a company health plan, a government health plan, or you are a healthcare clearinghouse. You're somebody that processes non-standard health information you receive from another. Put it in an electronic format or take it from an electronic format and put it into paper. And the reason this occurs is because when things go out electronically, the check's in the mail. Next slide, please. You can't retrieve it once it's already out. And the big issue with data is, unlike most objects that we see, this pen, for instance, my computer, my notebook, if someone takes it, I can look and see that it is gone. When someone steals data, the data doesn't disappear unless you can't get into a system because of some type of ransomware, but that's different. The data doesn't disappear. It's still there. So your contracts have to say, these are the methods I take to protect the data. These are the financial mechanisms that I have in place. And you'll see with my little slide there, as we go to the next one on covered entities, not everybody is a covered entity. You are the yellow umbrella in this slide. The coal-colored umbrellas, they're not covered by the business associates contract. They may be covered by other things, the California Consumer Privacy Act, the New York Department of Financial Services Act, the Federal Education Act. So here is the blood and guts of what has to be in the business associate agreements. You must execute, meaning you must sign, and you must perform, meaning you must do in accordance to those agreements that require the business associate to maintain the privacy of PHI, to limit the use or disclosure of the personal health information to the purposes authorized by the original covered entity. So if you're getting my healthcare information to take care of my terrible knees. Somebody down the line had doggone better not use it to see if I am creditworthy. And you have to assist other entities in responding to individual requests concerning their PHI. There is the link on this page that will take you to the Department of Health and Human Services. That is your guidepost, if you will, to what must be put in there. But let me re-emphasize these for a moment. You have to maintain the privacy, not the secrecy of the PHI. You can share it, but as per the second term, you can only share it for the purposes authorized from the onset. That means if I take Mr. Frankhauser's information regarding his tolerance to certain drugs and medications, I use that consistent with his original treatment, and I share it only with those other entities who need it to help perform the services, unless I have written authorization. So there's two prongs to that. All you have to do is put this in your contract. You don't have to say exactly how you do it, because how you do it will change over the course of time and over the course of performance. This requirement from business associates to put these clauses in their contracts isn't the Berlin Wall. It is not some impenetrable force. And as you will see when you go to the Health and Human Services portal, there are other terms that you can, and in my opinion, should put in there. When you go to those and you have that document with you as a supplemental document, when you go to those terms and you meet with your lawyer, say, oh, okay, and let's go to the next slide, please. There are other terms we can do. I'm not restricted to just these terms. I can add other terms. Do these make sense for our agreement? And the answer is, it depends. Now, there's a question that I'm going to anticipate here. What do you do if you have business associate agreements already in place and they don't have these privacy concerns addressed in them? Are you off the hook? Or do you still have to keep it private? Well, the answer is you still have to keep it private. That obligation is on you to make sure that the individual person is protected. Let's say you were a business associate. You don't have a contract with me who's going in for his knee surgery. Other people have a contract. So you and I don't have a contractual agreement. So I don't have a contract that I can try to enforce against you in the event you or somebody in your business decide that you're going to let my data out. The contract is enforceable between the parties, but that doesn't relieve anyone of the obligation to keep it private. So the security rule is different than the privacy rule. You still have to keep it private, but on the security side, it's with your contractual partner that you have to agree. And these other provisions that I strongly consider you recommend are along the lines of making sure that there are monetary solutions to any problem, because data breaches get really, really expensive. And we only have a certain amount of time, but under certain terms and conditions, a violation of the data privacy law means that notices have to be sent to the people whose data has been compromised. And I can tell you in the last few months, I've received 2 such letters. One data breach involved about 66,000 other people, 66,000 of my closest friends. Who's going to pay for those letters? Who's going to pay for the research that has to be done to find out how it happened? Who's going to pay the lawyer fees? Well, the answer is you should strongly consider putting an indemnification clause and see your lawyers for this, putting an indemnification clause into your agreements that say, hey, if you, the party with whom I have a contract, foul this up, and you let data out, and somebody sues me because I contracted with you, then you are going to come in and you are going to defend me, and you're going to hold me harmless because I'm not going to pay for your mistake. And that's generally speaking what an indemnity clause does. Remember I told you this was about money? It always is. And how do you finance those obligations? Well, you could dig in your pocket. I suppose that's an option, but it's not a very good option. And if I were contracting with you and you didn't have insurance for it, I might not do the deal with you, because I sure as heck don't want to sign a contract with somebody who doesn't take the time to finance their problems. We all get insurance for different reasons. And this is something, I don't want your company asset. What I want is an insurance mechanism in there to finance this. So you're going to have to figure out how someone's going to pay for the indemnity obligation. And if you're in the middle of a contractual relationship, the party above you is almost certainly going to insist that you indemnify them and you hold them harmless and you finance it with an insurance policy. And woe to you if you don't have this in your business associate agreement with the person behind you, because you are going to find that you're going to carry this bill. I don't think you want to pay for somebody else's problems. I don't like to pay for other people's problems. I know you don't. Now, these are all matters of state law. Every state has different contract laws, and that's what's a little tricky about this. But it's not so tricky that it can't be solved. In fact, it's pretty simple. Whether you can put a limitation of liability clause into your agreements is a matter of state law, and you and your legal representative should talk about it. But it's always something to consider, because it always strikes me as being odd that the company with $1 million revenue should have to totally finance the company with $1 billion of revenue. So I want you to consider that as we move to the next slide. And you'll see when you go to the Department of Health and Human Services and you look at their example of a business associate contract, you will see where these are among 3 clauses that they recommend that you follow. And because it's always about money, and it's always about money, you have to find the other opportunities to make yourself as clean as you can contractually. Now, I'll just a little sidetrack here. In my day as a litigator, the reality was very few cases that ever get filed go to a judge or jury. The percentage, the last I looked, was somewhere around 95% of all civil lawsuits filed in this country don't go to a judge or jury. That means that you're going to pay lawyer fees and never really get a decision, because 95% of the cases settle before there is any adjudication on the merits. Next slide, please. Okay, like I said, if you don't have a business associate agreement, covered entities and business associates will still violate HIPAA if there is no required BAA in place, because the law requires it. So you still have to comply with the rules. So don't think because you haven't addressed it contractually that you've dodged the legal bullet. No, the law still requires it. Next slide, please. And I know we're running out of time, so I want to get to the end of this.
We're on the wall of shame here, Steve.
I'm sorry?
We're on the wall of shame slide here, so you should be good to go.
Okay. Okay, the wall of shame is a different or slang name for the breach portal that is maintained by the Department of Health and Human Services. And the Department of Health and Human Services maintains that portal for 24 months. That's not 2 calendar years, but it's a total of 2 years. That will show you all the breaches that have occurred. And I want you to peruse that. You can do it, you can break it down and segregate it by state. You can segregate it by type, but it will show you how many healthcare records are involved. And this is a wall on which you do not want your name to appear, because it's a matter of public record. Just this week, a friend of mine showed me a record from, if you look on page 1 of the Wall of Shame as it exists today, from one of the businesses that had their records breached. They're going to change their provider in that regard. So here's what happens when you don't do this and your name ends up on the Wall of Shame. A, you get to defend a breach of contract case. That's always fun. There's always the potential to lose clients. You're going to have your reputation damaged. And by the way, when you look at the Wall of Shame, they'll tell you how it happened. You're going to increase the cost of your insurance. You're going to pay lawyers more. You're going to have to increase your marketing budget to recover from the loss of reputation. And frankly, as time goes on, you're going to lose good employees and keep bad ones. Because we are entering a new era, and our new era says that people, places are more concerned about their data than they ever have been before. And those of you on the West Coast or in Colorado, you're very much aware of the California Consumer Privacy Act and the new law that passed in November in California, very much like the General Data Protection Regulation out of the European Union. Those of you in Western Pennsylvania, New York State, West Virginia, Ohio, or all along the Eastern Seaboard, you're going to very quickly see how the state of New York is going to show its teeth on its data laws. HIPAA is way ahead of this. So you have to stay off the Wall of Shame. And frankly, when you do your due diligence in your contracts and your business associate agreements, you should be checking this Wall of Shame to see if your potential business associate has breached a data requirement. Is if they have, you're going to have a business decision to make. And they're going to have a very difficult time getting more insurance. Next slide, please. So there's nothing good that happens from a data breach, but I want you to consider this. And I'll be publishing a white paper at the end of this week. Nothing, no defense mechanism is entirely secure. No fortress. This is a war in which we find ourselves constantly attacked. Data is easy to steal because there is so much of it, and because we, me included, are so cavalier about it. Personally, when I go into a doctor's office now and I fill out a form and they ask for my social security number, I don't give it to them. And I haven't for several years. And I haven't had anyone call me on it. It's not your business what my social security number is. If you need it, call me. We'll sit down together and do it. So I want you all to also consider, as part of this business associate agreement requirement, that you adhere to special terms and conditions, that you stop taking in data you don't need. Now, on the privity of contract and statutory requirement, again, going back to the issue of, well, what's the harm? The harm is the statutory requirement makes me follow the business associate agreement law, whether I put it in the agreement or not. So if I lose somebody's data, I'm still going to be held to the privacy standard. But in the privity of contract, if I lose that one, if I haven't put it in my business associate agreement, I have all the joys of a lawsuit. I have a business, I'll use the expression partner in the generic sense. I have a business partner whom I've ticked off because I haven't cared enough to contractually protect them. And ask yourself, will you do business with somebody who won't contractually protect you? So there are distinctions as to what happens if you have a contract and you don't adhere to it. Because remember, you'll have to execute it and perform. That's the business associate law. I have to sign it. I have to do it. That's the contractual issue. The duty to keep it private is still statutory and still there. Next slide, please. And I apologize for the delay, ladies and gentlemen, but these materials are there, and we all have our opinions on the services provided by different governmental entities. I'm not here to give you my opinion on anything else, but I will tell you that I think the Department of Health and Human Services does a pretty good job. Because if you go to their website, you get the frequently asked questions section, you get their contractual language, you get the wall of shame. You're getting bang for your tax dollar there. And while they don't have, an omnipresent or ubiquitous police force to enforce these things, you do have the ability and the benefit of all their knowledge. So I am a firm believer in going to the Department of Health and Human Services website regularly, not annually, not semi-annually, once a month. Subscribe to their email notifications. All you have to do is look at the notification. If the topic doesn't apply to you or you think it doesn't, you delete it. But most of the time, that little bit of knowledge will pay dividends. So our conclusions are as follows. The business associate agreement must contain certain provisions dealing with data privacy and cybersecurity. Go to the sample I've given you in your materials and go to the Department of Health and Human Services. Just because you don't put those terms in a business associate agreement doesn't eliminate the need to keep this information private. The good news is perfection and total assurances aren't the standard. Everybody understands that you don't have the perfect organization and we don't live in the perfect world, but you have to try. 4, finance the obligation. Engage your insurance professionals. They'll help you. Always address the business purpose behind data privacy and security. Use your data privacy policies and your good data privacy hygiene to distinguish yourselves from your competitors. It's a no-brainer where I'm from. Wow, yeah, we take care of your stuff. You wouldn't send your car into a car wash that damaged it. So why would you send your data somewhere that does the same thing? And if I get hit by a lightning bolt later today and you can't remember anything or you lose this, remember that data privacy and cybersecurity, good hygiene is not static. It changes. We are in an evolving time and it goes rapidly. And I want you to go back to the information that I shared with you about the amount of data from the beginning of time through 2015, the amount of data created in 2016 alone, and the amount of data and when it will double every 12 hours. It's only going to get more challenging. Don't put a program in place and let it sit on the shelves. Data is our raw material, especially in your business. Especially in your business. You're using data. You're transmitting electronically. Take care of it and constantly figure out the best way to do it. So any questions would be great. I know we're a little bit over time. My apologies for that. I'm sorry, my passion got the best of me.
No, appreciate it, Steve. Thanks so much for the insight and content. Yeah, as I mentioned earlier, I know Tina was monitoring the Q&A. So, Tina, if you're still with us, if you want to jump in and ask the questions.
Sure, we got a bunch. So the first one is the business associate responsible for getting the BAA in place if the covered entity doesn't request one?
Yes. Yes, the answer is yes.
Okay.
Now that doesn't mean you can force it on them, Tina.
Mhm.
But the fact that you will have asked for it and addressed it, I mean, you can't force somebody to sign a contract they will not sign. But you certainly can ask for it. And ultimately, that becomes a business decision and whether you want to continue to do business with that entity or not.
Okay. Do all contractors have to have a BAA? Should I take like a better safe than sorry approach? Like, do I know for sure whether or not they're working with the PHI?
Yeah, so ultimately the question is, do I qualify as a business associate?
Right.
And if it's not going to cost you anymore and you think you're on the edge, I'm always a fan of belt and suspenders. Because the thing that always concerns me is, yes, I know what laws say, but I also know that when lawsuits come, lawyers have different interpretations of the same language, and judges sometimes look for clarification. So my business advice would be, if you think you're close to being a business associate, include it.
Okay. And if we're on the other side, we're a small practice and we've got lots of contractors. I think that's what was coming from that side, that question. But we'll move on. The next
well, if you
one,
have lots of contractors, then I'll go back to my example, Tina, of the $1 million annual revenue company indemnifying the $1 billion annual revenue company.
Okay. All right. So
my suggestion is that you scale it to the amount possible. And I've had experience with this. At some point in time, you sit down with the party you're negotiating with and you say, hey, Tina, I'd love to insure you to $12 billion, but I can't get that kind of insurance. Will you accept this amount of money on my insurance if I have it? Because what I don't want to be is I don't want to be the company that ends up holding the bag. And that always is a business decision, and I get it and I understand it. So that's why I said, look at your limitation of liability clauses in the state you're in and see if you can handle it that way.
So I got two that are kind of the same thing. So it says we use a template for a BAA that I got off the internet. How do I know if that's okay? And then another question, kind of the same thing. It said, what should I do if my BAAs don't currently have these provisions?
Okay, well, the internet is not a reliable source just for that. So it depends where you got it. So that's answer part A to answer or to question number one. Part B is, remember I said they're not commodities, they're agreements. Well, my suggestion would be that you compare the language that you have with the one you found in the internet compared to the one that's on the website for the Department of Health and Human Services. So the authenticity of the website is always an issue. And then 3, ask your lawyer. It's really not that difficult. The second question, what do I do if I don't have one? Well, I always go back to my law school professor that says, in those situations, you pick up the phone and you call your contractual partner and say, hey, Dave, Susan, we're doing an inventory of our contracts. We don't have these clauses in there. Listen, we're going to be held to this standard anyway. Let's work to put them in. And if we can't get them into our existing agreements, and that's not always possible, people don't always want to assign amendments, let's make sure that we can start incorporating them from this point forward.
Okay. And then we have a long one, so I'll start at the beginning. As a covered entity, to what extent must I perform due diligence on a business associate and their possible subcontractors on their HIPAA compliance. Can the covered entity ask for proof of HIPAA policies and procedures, plus HIPAA staff training for the business associate and their possible subcontractors? Ultimately, even if there is indemnity clauses to protect the cost associated with a breach, they are reputational costs to the covered entity. A breach ultimately causes patients to question and or leave a practice. So as a covered entity,
Well, that was an easy question.
yeah, to what extent must I perform due diligence on a business associate to make sure that that business associate is has met their HIPAA compliance?
Yeah. Well, there's no law that says you have to take X number of steps, Y number of steps, turn right at the yellow brick road, turn left at the yellow brick road. Okay. It's a reasonableness standard. That, frankly, is up to your comfort level. So the absence of due diligence is in my mind, will never satisfy it. So ultimately, remember this, it will be your reputation. At a minimum, I want to see, now I'm also a certified information privacy professional under US law. I will tell you the first thing I look for. The first thing I look for is insurance. And I want to make sure it's applicable. Now, you can do due diligence till the cows come home, but you don't have unlimited resources and you don't have unlimited time. So I would prioritize it, and I would first look to the insurance protections that are there and make sure they're applicable. After that, it's a matter of comfort for you. And my suggestion is you will never find the perfect entity. What you want to look for is their policies and procedures, their training, their turnover. I understand you have to put an end to it at some point in time. That's according to your level of risk tolerance, understanding that nothing is risk-free. So there's not a time component involved. There's no requirement that you take certain numbers of steps. But I will tell you, the first thing I look for is, where's the money?
Okay, well, thank you. That's the end of the questions.
Wonderful. Yeah, as Tina said, Steve, thanks so much for joining us this morning and providing insight. We hope everybody enjoyed today's session. Apologize, we did go a bit over, but if there are any additional questions or items that you'd like to further discuss with Steve, or if there's questions regarding data security or other IT-related issues that you may be experiencing, both my information and Tyler Lewin's is there on the screen. Please don't hesitate to reach out to us, whether it be by email or phone. We're here to help. We're here as a resource for you. And with that, we'll wrap things up and hope everybody has a great rest of the week.
Stay healthy, everyone. Thank you.
Thanks so much.
Thanks.